testing. Okay, welcome to the Public Service Commission's administrative meeting for May 22nd, 2024. First item of business is to approve the minutes from our meeting of May 15th. Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Morning, Mr. Chair. At the outset, we will defer item number 8 to the June 12th, 2024 administrative meeting. There are 4 items on today's consent agenda. Items 1 through 3 are revisions to standard offer service rates for the Potomac Edison Company, Delmarva Power and Light Company, and Potomac Electric Power Company. And item number 4 is a request from Capital Business Advisors, Inc. to cancel its electricity supplier license.
Okay, so regarding item 1, I move that we accept the tariff revisions for filing with an effective date of June 1, 2024. Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye. Regarding item 2, I move that we accept the tariff revisions for filing with an effective date of June 1, 2024. Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye. And then regarding item 3, I move that we accept for filing the revised SOS tariff pages, inclusive of a correction of the total SOS kilowatt reflected in the R-TOU-P service class with an effective date of June 1, 2024, and direct the company to file clean copies of the revised tariff pages. Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye. And regarding item 4, I move that we approve the cancellation request. Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Mr. Chair, item number 5 on the administrative agenda consists of tariff revisions from Baltimore Gas and Electric Company.
Good morning, Mr. Chair and Commissioners. Alden Manka on behalf of staff. On April 12th, 2024, Baltimore Gas and Electric Company filed Supplement 505 to PSC MDG9, which revises their tariff pages to include changes to the comprehensive balancing service price and self-balancing service price for daily metered customers. BGE is required to balance all gas volumes transported on their system and is assessed costs for any storage associated with an over-delivery or under-delivery of gas. Daily metered customers are required to pay a fee to cover imbalances in gas delivery to offset the costs to BGE to balance the system. The fee is determined by the costs to the company associated with gas storage. Daily metered customers have 2 gas imbalance payment options. They can either use the comprehensive balancing service, which is a flat fee for each therm they use, or the self-balancing service, which has an escalating fee for each therm out of balance. BGE is proposing to lower the comprehensive balancing service fee from $0.0007 per therm to $0.004 per therm, and reduce the self-balancing service fee from a weighted average cost of $0.00627 per therm to $0.00491 per therm. Staff recommends the Commission accept the revised tariff pages for filing with an effective date of June 1st, 2024. Thank you, and I am available for questions.
Any questions for staff? All right.
Good morning, Commissioners. Beverly Sakura on behalf of BGE. We have no comments, but we're here for questions if you should have any.
Any questions for BG&E? Seeing none, I move that we accept the tariff provisions for filing with an effective date of June 1, 2024. Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Item number 6 is a petition from MCI Metro Access Transmission Services, LLC, DBA Verizon Access Transmission Service, for a waiver of the denial of numbering resources.
Good morning again, Mr. Chair and Commissioners. Alden Manka on behalf of staff. On April 18, 2024, MCI Metro Access Transmission Services filed a request for a waiver to overturn the North American Numbering Plan Administrator, NANPA, denial of the company's request for 6,000 blocks of consecutive numbers. The company made this application for numbers due to a request from a business customer for consecutive numbers, which the company could not meet with its current inventory. These numbers would be used to support the business customer's transition to voice-over IP services, retire copper infrastructure, and prevent overlap in the customer's internal dialing plan. NANPA denied the request because the company did not meet the utilization rate requirement or the months to exhaust requirement. Federal Communications Commission Order 01-362 describes the safety valve mechanism that delegates authority to state commissions to direct NANPA to assign numbering resources when a verifiable need for additional numbering has been demonstrated. Staff believes this use case constitutes a verifiable need for numbering resources and that NANPA's denial of the requested numbers be overturned. Therefore, staff recommends that the Commission grant a waiver for MCI Metro Access Transmission Services to obtain the requested 6,000 blocks of consecutive numbers from the North American Numbering Plan Administrator. Thank you, and I am available for questions.
Any questions for staff? Okay.
Thank you, Mr. Chairman and Commissioners. My name is Doug Smith, Vice President, State Government Affairs for Verizon and the parent company of MCI Metro Access Transmission Services. We support staff's comments, summary, and recommendation. I'm available for any questions you may have.
Any questions? So one question for me. It seems to me we've had, I don't know, 2 or 3 of these requests. And I guess what I don't understand is it routine for the North American Numbering Plan Administrator to initially deny these requests, and then that's how you get here?
Yes, we've had a couple of these in the past, you're right, and it's all a formulaic analysis by the FCC. If Verizon, or MCI in this case, has any inventory left of telephone numbers, they routinely deny that request, but provide that safety valve, knowing that there could be customers like this that make massive requests for 6,000 numbers.
Okay. So with that, I move that we grant the company a waiver to obtain the requested 6,000 blocks from the North American Numbering Plan Administrator. Commissioner Sushman.
Aye.
Commissioner Barve. Aye. Commissioner Richard.
Aye.
I vote aye.
And item 7 is a request from Alago Energy MD LLC to expand its electricity service license.
Good morning, Chair and Commissioners. Charles Herbert on behalf of staff. On April 27, 2023, Alago Energy Maryland LLC, Alago, or the company, filed a request to expand its electric supplier license to serve customers in the Delmarva Power and Light Company, or DPL, and Potomac Edison Company, or PE. After having operated in DPL and PE without the sufficient permissions on the company's license. On August 2nd, 2023, the Commission considered the matter at the Commission's administrative meeting and deferred the matter. The Commission issued bench requests that 1. Staff find out if a show cause proceeding against Alago is warranted, and 2. Staff take another look at fining for Alago's violation. After months of negotiations, staff, OPC, and Alago agreed to the terms outlined in the settlement agreement on May 15, 2024, where staff and OPC recommend the approval of Alago's expansion request when Alago is subject to the following obligations. 1. Alago shall increase the level of security on file with the Commission pursuant to COMAR 20-51-02-08 and 20-54-02-08 to $500,000. 2. Alago shall pay $183,088 into the Maryland Public Service Commission for deposit into the Education and Protection Fund under Sections 7-310, 13-201, and 7-507 of the PUA. 3. Alago shall send a letter to its current DPL and PE customers notifying them that A. At the time the customer enrolled, Alago was not properly licensed by the Public Service Commission, but Alago has now cured that deficiency. B. The licensing issue has not affected and will not affect any customer electricity supply service from Alago or any customer's contract with Alago. C. The customer may leave Alago's service at any time without a termination fee. The Commission's Consumer Affairs Division, or CAD, has informed staff that CAD is not opposed to this joint settlement agreement. Accordingly, staff recommends that the Commission approve the settlement agreement and approve Aligo's expansion request for commission authorization to serve customers in the DPL and PE service territories. And with that, staff is available for questions. Thank you.
All right, so my initial question is, it seems to me we've had, I don't know, 2 or 3 of these situations where companies have been apparently operating without a license in service territories. So I guess my question to staff is there some flaw in the process that we go through to grant these initial licenses that causes this to happen?
Every time we've seen this happen, which a different situation than what we've seen with some brokers with they didn't have a license in the first place. Whenever this has happened, we've typically known it to be a clerical error with the company, and as whoever has gone through the Word document that we have our templates on the website for the applications, and as they're checking out the boxes, it's typically been the case that whoever was filling that out just didn't forgot to select whatever box or didn't select whatever box.
But there's no verification done by staff to sort of like catch this problem, because it seems to me you've only become aware of it when either they've like self-reported it because they want to do something else, and like in this situation, apparently it's been going on for some period of time.
So when staff processes supplier applications, we have the filing to go off on, and we're under the presumption that whatever service territories the company signs up for are the service territories they intend to operate in. And at least I haven't seen any cases where we've, unless something comes up and we hear from the company that, oh, we actually intend to operate in these territories as well, then we would inform them in our email communications with the company through the process.
All right, so the last question is, I mean, is it potentially possible that there are other companies that are doing this exact same thing? I mean, is this like a rampant problem in this industry, or because it strikes me that, you know, if it happened once, it's like one situation, but now we're on, I don't know, like I said, either at least the second or third instance of this situation happening, and that's just since I've been here, and that's only from July of last year.
I haven't seen, I can't say I've seen any other instances of this, and I can't speak to how rampant the problem may or may not be. As we discussed it, I think the prior administrative meeting, staff discovered this during when we sent out a cease and desist letter on another matter related to the website, and we went through the service territories and looked at all the documentation and then determined that there was a mismatch in what the company was signed up for on the application sheet and where they were actually operating. But that being said, unless there's a situation like that where staff sort of revisits all the documentation, or there's a history of, we have an actual operation history of the company, as opposed to just the initial application phase, we typically wouldn't have any way of knowing whether this problem exists for a given company.
All right. Any other questions for staff? Commissioner Stuchman.
So going back to the filing from last year, staff had recommended that we approve the expansion, but also noted that there were a number of complaints against the company, and I guess the concern I have is I'm not convinced that we're dealing just with a clerical error, or we're dealing with a company that made an error but also has a history of complaints. And I appreciate you sort of engaging in a settlement agreement, but the settlement agreements seem to be focused on things that already happened. And I'm wondering if there's a way to include some kind of monitoring so that we can be assured that the problem was in fact just a clerical error and not something more. So do you have a recommendation?
Yeah, I'll defer to Mr. Wilson on this question.
Okay, thank you.
Thank you. Peter Wilson, on behalf of staff. Yeah, the settlement agreement includes a reporting requirement, which would be monitoring going forward. I think originally when we first filed comments a year ago, we went back several years, and over several years there were 25 complaints. We don't know, most of those had been resolved, some in the company's favor, some in the customer's favor. CAD did not think it appropriate to go forward with a show cause at this time, and in the last year, we haven't seen a problem, but we do have the monitoring aspect going forward to make sure
Okay,
there isn't
and well, so I'm looking at the settlement obligation. So the monitoring requirement is where? I'm not seeing it.
Section 5?
I have 1, 2, and 3. Unless there's there is, I see. Okay, so section 5. This was on page what of the settlement agreement?
4, it looks like.
Page 4.
Okay. Okay. Okay, and you think that that's going to give you the kind of information that you need to be able to determine if the problem is more than just clerical?
We do.
Okay. Okay, thank you.
Any other? Commissioner Richard?
Yeah, just kind of following on the same line of questioning as the chairman. When we authorize one of these applications, is there any kind of notification sent to the utility, alerting them that, yes, this company is authorized to operate in that service territory? Because it seems the utility then has to then, when interact with the retail supplier, switch a customer to the retail supplier, and then also set up kind of a purchase of a receivable agreement. So I mean, what happens there? How does a utility know that that's an authorized company? Because it seems like, again, a lot of these, we're getting a lot of these findings that there's been mistakes made.
Yes, Kevin Mosher on behalf of staff. Yeah, the utilities won't sign someone up unless they are licensed. However, I don't know that all the utilities are looking specifically at the details of the application and saying, have we checked off? Now, I will say SMECO in particular is very diligent. Anytime someone wants to go into the SMECO service territory, they'll contact, I think every time they contact me to verify, hey, did this company actually check off the SMECO box? The other utilities may just be relying on, they have a license in Maryland, they're authorized. And I think the other thing, I'm not sure if the utilities are looking at this the same way maybe the commission and staff are, that if you don't, say, check off Potomac Edison, that means you don't have authorization in Potomac Edison, versus the utilities may be thinking, and again, this may be something that staff needs to get together with utilities to try to make sure this doesn't happen. The utilities may be thinking that, well, that just means you weren't operating there, when you got your license, but you may want to later. So again, if the commission is concerned about this, staff can take steps to, again, work with utilities and to try to make sure that, in the 10 or 15 years I've been doing this, I think we've only ran into this maybe a half dozen times or so. But again, if there is concern, we can take steps to help ensure that this is less likely in the future.
Okay, well, thank you. It's good to have that information, but again, along the lines of the chairman's question, that it's it just seems odd that this kind of a mistake is being made, that somehow there's not a check to make sure that a retail supplier is in fact authorized to do business in the service territory. So yeah, it seems like maybe half a dozen times, but that seems, again, like a mistake that should not be made.
Okay.
So thank
Well,
you.
we will definitely, staff will look into this, and off the top of my head, I think of a couple of different methods we can use, but I think we can pretty quickly investigate this and see if this is a wider issue.
Well, I guess my concern is, I don't necessarily think that the utility should be the policeman for this. I mean, I think it's perfectly reasonable for them, if they get, a request from, this company to, switch a customer to them, it's not really the utility's job to make sure that they've got a valid license. I mean, obviously the fault is initially with the retail supplier, but to a certain extent the fault's with us, if in fact, these things are happening. So I don't necessarily want to have a situation where the utilities have to do some verification, even if it's calling you to find out if the license is valid. I mean, there should be some way to fix this problem other than deputizing them.
Understood.
Okay. So,
Good morning, Mr. Chairman and Commissioners. It's a privilege to appear before you for the first time today. Milan Tekla-Mikhail on behalf of the Office of People's Counsel. OPC supports staff's recommendation that the Commission should approve the settlement agreement, as well as Allego's request to serve customers in the Delmarva and Potomac Edison service territories. Per the Commission's instructions at the August 2nd, 2023 administrative meeting where the matter was last heard, OPC has worked extensively with staff and Allego in order to reach the settlement agreement, which includes a civil penalty amount that reflects a percentage of the company's total gross revenue garnered from its operation in the unlicensed territories. OPC believes the recommended civil penalty amount demonstrates the seriousness and gravity of Allego's infraction of operating in the Delmarva and Potomac Edison service territories without prior authorization by the Commission, but also takes into consideration as mitigating factors the company's good faith efforts to achieve compliance after notification of the violation, as well as its reporting to the Commission on an annual basis its Delmarva and Potomac Edison customer revenues within its annual revenue and RPS reports, as well as paying applicable Maryland taxes and fees related to such revenues. Pursuant to Section 13-201D of the Public Utilities Article of the Maryland Code and the Commission's licensing authority under PUA Section 7-507, OPC recommends that the Commission approve the proposed settlement agreement and also Allego's request to expand its electric supplier license conditioned on Allego meeting its obligations under the settlement agreement. Thank you.
any questions for OPC? All right.
Morning, Mr. Chairman, Commissioners. Brian Green for Allego Energy. We're pleased to enter into this settlement and put this matter behind us, hopefully, today. We filed this application, we self-reported on April 27, over a year ago, 2023. And so we were here last August, almost a year ago, and we heard loud and clear the Commission's concerns about the recommended penalty at that time, which was $2,500. So this settlement is a somewhat landmark agreement in situations where there's this licensing snafu. And I'm happy to answer any of those same questions, Mr. Chairman, that you posed to staff. I've been representing suppliers and dealing with these types of issues for 20 plus years here in Maryland. I was in all the working groups in the early 2000s where these applications were discussed and so forth. And so if you want to run those questions by me here or offline, I'd be happy to chat with you about them, how to make the system better so that this problem doesn't come about. I think it is important, though, just to take one moment, a little tangent. There's two types of, what I've seen in my experience, is that there's two types of issues where this problem presents itself. One is typically a broker that is doing business elsewhere, but then has a one-off or starts doing business in Maryland and doesn't realize that they need a license, or doesn't even realize that a facility is located in Maryland. So that's one issue. The supplier issue is really more about just checking boxes on the application. And I can tell you that when that application was first drafted, it was not intended that suppliers would be licensed by jurisdiction, by service territory. That's why you have one bond for electricity, the financial integrity bond of $250,000. It doesn't matter if you're in one jurisdiction or numerous jurisdictions, all 4 of the investor-owned utilities. It's a $250,000 requirement. So my recollection is that when the checking of the boxes was simply so that staff and the commission could see where is this supplier intending to market their business. So that's number one, and then that follows through to the second issue, which can be improved, is the letter order that gets issued for the applicants. It says you're licensed as described in the application. So that means that even if the utility was the gatekeeper, right, when you go to them for testing, they'd have to, it's not just showing them the letter order, right? Then someone has to go back and find the application and show it to the utility. So it's and what has happened here with Eligo is that they were initially licensed in 2012. There's turnover at the company. They're doing well. They're starting to build their book in BGE and Pepco, and then they decide to expand their service throughout Maryland. And no one at the company realized that, oh, we're licensed by service territories in Maryland? We didn't know that. So when it was brought to the company's attention, they immediately ceased the marketing in those service territories and self-reported, because if you may recall, Mr. Chairman, former Chairman Stanek, during his maximum enforcement period, was spending numerous admin meetings telling suppliers, self-report, self-report, self-report. If you have an issue, bring it to us. We cannot absolve you of your penalty, but we will look favorably upon the fact that you self-reported. That was the decision that the company made last year to self-report once we found out about the problem, thanks to staff, and we came in, hopefully, to resolve this quickly. Didn't happen so quick, but we're here now, and we're happy that we could enter into this settlement. It is, I believe, Commissioner Suchman, you were very instrumental in your questions last year in August about what's the nexus between the penalty and the business that you've done in Maryland, and whether it's gross revenue or some other nexus. And we, in settlement negotiations, went through a lot of different methodologies, and this is what we came up with, which is a percentage of gross revenue. So it earned in the service territories, as OPC counsel said, and it comes out to a big number, frankly, $183,000 and $183,088, which is just slightly higher than $2,500. So this is a big number, but again, the company just at this point is. And then there's a lot of other stuff in the settlement agreement. I'm happy to answer any questions about it. But we're delighted to put this behind us and move on and see what other business can be done in Maryland. And if not, then at least the matter will be over.
All right, so I've seen the application, and it has these boxes that essentially you check as to where you're going to offer service. And so obviously when the company showed up here to initially do business in the state of Maryland, they made a decision that, yes, we want to solicit customers in BG&E service territory and Pepco's, but not these others. And I guess I find it hard to believe that, when they decided that, oh, let's start going other places, that they didn't think that, well, we need to update the license to make sure that we're authorized to provide service in this. I mean, it seems to me, that license says to you, look, you can solicit customers in these particular parts of Maryland, but not these other parts. And so I find it, just difficult to believe that, it's like, oh, well, this was just sort of happenstance, and particularly happenstance that went on for apparently some period of time.
Well, I think that's the point, right, is that it went on for some period of time because the company was acting as if they thought they were licensed throughout the state, which Maryland, to my knowledge, is the only jurisdiction where there aren't just a statewide license. There's
Right.
Licenses by service territory. So this is a company that operates in more than one state. So
Well,
I think the people
that being said, it strikes me that they ought to have enough wherewithal to figure out what the rules of the game are in the various places they operate. You know, I'm sure there's other requirements in other states that are different from us, and it seems to me it's incumbent on the company to figure out what the rules of the game are before they start doing things.
I don't disagree with you. I think that most suppliers will probably tell you that the emphasis on that, on figuring out what the rules are in that state, deals specifically with consumer protection, and not. And now the trend throughout many states is licensing renewals, but not are we licensed? Did we get our license? Back in 2012, or that's not the question that the compliance folks are looking at. They're looking at are we following the consumer protection violations properly? So I don't know if that's a satisfactory answer, but that's probably what the emphasis is on the ground.
Any other, Commissioner Sushman?
So, speaking as somebody who's been involved in this process since the beginning, do you recall why the decision was made to license by jurisdiction as opposed to by the state as a whole? Was that a requirement in law, or Mr. Spivak, would you know?
Well, also as somebody who has been here since the beginning of this process, I can verify that what Mr. Green said is correct. At the time, it was not viewed as serving by service territory, as the licenses actually being limited to by service territory. It was viewed as those boxes were informational. There is no requirement in the statute that it be by service territory. We have just, that view has seemed to evolve here. And really, what's happened here, it was not actually the company operating unlicensed because they did have a license in Maryland. It was not updating that license or the information that they supplied with their application to inform us that they were going to be serving in those additional service territories, and that's really the violation that occurred here. The license itself, when the Commission grants the license, the Commission does specify that it is for the service territories specified in their application. So, in that sense, there is a violation of that order as well.
So is there a benefit to identifying areas of service within a license as opposed to being licensed in the state as a whole?
Not really, other than it just gives us an idea of where they're actually operating. But there really isn't any specific benefit that you could really discern from having the licenses limited by service territory. Like I said, it just gives us the opportunity to understand where they're operating and which customer groups they're aimed at. I think it was originally intended to be more informational than anything else. The other thing is there is a little bit of distinction, I suppose, between the service territories as to whether there is choice, certainly originally between the cooperatives and the utilities, and also between, and the investor-owned utilities, and also between the municipal utilities and the investor-owned utilities. In those service territories, there was no customer choice to begin with, and even in some of them, there may not be to this day.
I mean, I'm sort of thinking out loud, which is sometimes a mistake, but I'm wondering. I mean, I don't think there's any question that you operate in Maryland. You need to know what the rules of the road are here, and that's really important, especially because you're dealing with consumers, and so that is just so critical. But if this is a requirement that can trip up companies, and the requirement itself may not necessarily be required, maybe this is something that you can take back and think about whether going forward this is. I mean, certainly you can identify it as an informational requirement as opposed to a condition for the license, for example. And so, I mean, maybe this is just something to think about as you're also thinking about how you can sort of have within staff the ability to kind of automatically let people, customers know, utilities know if an entity is licensed or not.
Yeah, I mean, now, there are limited resources in terms of the number of staff people that address these issues. And that's one of the issues we have with ongoing monitoring, in depth of any supplier actions. But I would think the information should be made available through the Commission's website, for example, or could be made available there if it's not already.
Well, for example, if the state only had a licensing requirement for the state as a whole, as opposed to each jurisdiction, that's probably an easier system to maintain, and the alert is just a single alert as opposed to multiple alerts.
Well, I mean, as it happens, that information already is on the Commission's website. I mean, whether or not a supplier is licensed is there. Like I said, I'm not sure if it necessarily extends to what specific service territories, although if there are, to the extent that it does, the website does provide information on offers that are out there, they would probably specify in which service territories those are available.
And Mr. Green, is this, I mean, I would assume from the perspective of the companies you represent, having a single licensing requirement as opposed to licensing requirements in multiple jurisdictions would make it easier and less of a possibility that your clients would trip up over failure on this part of the process.
And this honestly, and I don't mean to offend anybody here, but the failure to check a box and then have the supplier go out and pay all the assessments as if they were fully licensed and pay their taxes like they're fully licensed and count all the kilowatt hours for RPS purposes and compliance, and then have to come back and go through a process like this only because they didn't check a few boxes on their application, but they've remained financially, into the integrity bond is there, everything else is fine, it doesn't seem like a very wise use of a company's resources. And so,
Well,
yes.
I think there are different issues. I mean, whether you think a requirement is sensible or not, if it's a requirement, your client has to meet it. I'm just sort of wondering, for the future, if the requirement that you be licensed in every jurisdiction is something to reconsider.
I would say wholeheartedly yes, because the advice that our firm gives our supplier clients when they begin filling out applications in Maryland is check all the boxes, because you don't want to have to go back. And if you eventually get to a point where you're going to market in that particular service territory, good for you. You don't have to go back and and spend months trying to get additional permissions. You already have them. So yes, it would make it much easier. And not have to just check boxes for the sake of hopefully one day getting to those service territories.
But obviously, your company in this situation didn't do that.
That's
And so they applied to sort of offer service in some parts of the state and then decided at some point down the road to do it everywhere. So it strikes me as almost, what's the point of having this requirement if, the idea is that you can be authorized to provide service in this area or that area, but you wind up, providing service everywhere. And it seems to me that these companies should be have enough resources to understand, here's what we got to do to comply with the rules and regulations in the various states that we operate in. That's part of the deal of being a multi-state company. You have to figure out what the rules are in those particular states, and it seems to me it's incumbent on them to have that and not just say, oh, gee whiz, we forgot or didn't do it or whatever. I mean, it just strikes me that these excuses are not very convincing to me.
Well, and that's probably a good segue back into the settlement, is that, the settlement is In the past, when this has happened, it's been a flat, and it's been several years, right, since something like this has come to the commission. That's, as we learned last year in August, it's been a $2,500 penalty, and then everyone goes on their way. Here, the company is putting $183,088 on the table, and they're agreeing to reporting. They're agreeing to send a letter out to customers. They're agreeing to increase their financial security bond by twice the amount from 250 to 500. So they recognize that the way that the application has been interpreted after it was advised, after staff told them what they were doing wrong, that there's an issue here, and so they're not running from the fact that should they have known? Yes, because that's how things have been interpreted the last several years here, more than several years. But they didn't go back and check to see were they licensed there. In fact, when they signed up to get tested in the Delmarva and Potomac Edison territories, I don't know what they provided to the utilities, but I don't think there's nothing nefarious here. They didn't intentionally try to say we're not licensed there, but let's see if we can slip it by them. It's simply they thought they were licensed in the whole state, and so we recognize that, and we've worked hard with OPC and staff to try to get on the same page. It's not easy to broker a settlement with such diverse interests on supplier-related issues. So it's been a lot of emails and a lot of phone calls and a lot of sharing of data, and we were fortunate, I still think, to get to this settlement, which is in the public interest, and I ask that it be approved.
So, any other questions? So,
Mr. Chairman, OPC would like an opportunity to provide perspective on the licensing requirement matter. I think that if the commission is thinking about, changing its methodology as to the application requirements, there should be a notice and comment opportunity to do that. And in conjunction, I think SB1 also touches on this issue because there's a requirement within SB1 for the retail suppliers to apply for relicensing every 3 years, I believe. So there are a lot of different angles to this to be considered, and we just wanted to.
Yeah, and I actually was going to mention the fact that, there's not necessarily a new sheriff in town, but there is a new law in town, and obviously as part of our implementation of SB1, we're going to have to figure out what the new requirements are going to be for the renewal of licenses, and I suspect this issue will become a prime topic of what we're going to do going forward. So, Mr. Trout.
Thank you, Chair Hoover, Commissioners. My name is Jeffrey Trout. I'm counsel to Potomac Edison for a few more weeks, and I wanted to share with you a utility perspective on the matters before you this morning. Like Mr. Spivak and Mr. Green, I was here 20 years ago when these rules were created, and my recollection is exactly the same as theirs, that the intent, the original intent, which may have evolved since, but the original intent was a statewide license. The checking of the boxes was informational, and we discussed in the work group meetings that most suppliers are going to start off in the BGE service territory or the BGE and the PEPCO service territories, or if they were really ambitious in the BGE, PEPCO, and Delmarva service territories, where most of the customers were that were expected to shop, and that later on, if a company got a foothold in the state that they thought was sufficient, they would expand into our service territory and into SMECO's service territory. So that was how we started all of this 20 years ago. We are obviously in a different place now. I am supportive of your comments, Chair Hoover, that the utilities not be made the police here. I am supportive of the idea that this is something that, in the context of looking at the broader issues raised by SB1, which we will need to do and which we will need to do in short order, that this issue be revisited. But mostly I'm here to reinforce to you that Mr. Spivak and Mr. Green are telling you exactly what happened 20 years ago.
Okay, so any questions for Mr. Trout? All right, well, I'm going to go ahead and move that we approve the settlement agreement and approve the company's request for authorization to serve customers in the Delmarva Power and Light Company and Potomac Edison Company service territories. That being said, I do think that this issue needs to be examined so that the licensing requirement, has the effect that we want to have on it. The reason why SB1 got passed and signed by the governor was concerns with this industry, which, the General Assembly and the governor weren't convinced could be adequately overseen by the current laws that were on the books. And so now they've created this whole new process. And the important part of that process is this renewal of the license. I think there's obviously a concern about how these companies have been operating, and the General Assembly has decided that the licensing aspect of this is one way to try to control the actions of these companies. So going forward, we're going to have to pay close attention so that the licensing requirements, mean what they say. So if you're required to do certain things, you have to do them, and not just, it's just, letting us know from an informational standpoint. It's actually a requirement. So that being said, Commissioner Sushman.
Well, I'm totally agreeing with the chair on his comments, and aye.
Commissioner Barbe.
Me too, aye.
Commissioner Richard.
I wholeheartedly agree with the chairman, and aye.
I vote aye. And with that, we're adjourned.